Welcome to Talking Straight. I'm Suresh Kochattil. On Monday, a 5-judge Constitution bench of the Supreme Court with a majority of 3:2 upheld the validity of the Constitution's 103rd Amendment Act 2019, which provides 10% reservation amongst the economically weaker sections of the society, which hitherto did not have any access to reservation in jobs or education. The 103rd Constitutional Amendment Act, which the Centre had approved in January 2019, included a quota for economically weaker sections in education and jobs. The challenge in the Supreme Court questioned if the quota had altered the fundamental structure of the Constitution and how it could exceed the national ceiling of reserve of 50% imposed by the Supreme Court themselves in 1992. The majority bench of Justice Dinesh Maheshwari, Bela Trivedi and Justice J.B. Pardiwala upheld the EWS Amendment Act, while Chief Justice, that is the outgoing Chief Justice who is now just retired yesterday, CJ U.U. Lalit and Justice Ravindra Bhatt dissented. Let's look at some of the highlights of this judgment. Reservation is a tool used by the government to take affirmative action, said the judges. Reservation based on economic criteria does not violate the Constitution's fundamental principles, said the majority judgment. Excluding groups covered in Articles 15.4 and 16.4 is not against the law and does not undermine the foundation of the society, said the 3 judges who actually supported the judgment. Due to the 50% upper constraint, reservations for the EWS does not contradict the fundamental framework. Exclusion is prohibited under the Constitution. This is what the judges had said. The views of the EWS bench of Justice Dinesh Maheshwari, Justice Bela Trivedi, who upheld the act of the EWS reservation, said that the state can create special provisions and exclusion of socially, economically backward classes, scheduled tribes, scheduled castes and other backward castes, and does not violate the equality of law. Justice Trivedi had said that the reservation should have a time frame to bring about an egalitarian society and something that the founding fathers of our Constitution had envisaged. Justice Pardiwala held that the EWS reservation may be perceived as a first step in the process of doing away with a caste-based reservation, which in his opinion, should not continue for an indefinite time. Justice Pardiwala held that the spread of education has resulted in the tapering the gap between the different classes for a considerable extent. Therefore, as a larger percentage of the backward class members attain an acceptable standards of education and employment, they should be removed from the backward tag that they have, the backward categories tag they have, so the attention can be paid towards those classes which genuinely need help. The idea that Dr. Babasaheb Ambedkar was to bring about a social harmony by introducing reservation for only 10 years. However, it has continued for the past 7 decades. Reservation should not continue for an indefinite period of time so as to become a vested interest, said Justice Pardiwala. Justice Ravindra Bhatt, who had dissented, said that while the EWS quota appears to be based entirely on economic distress and poverty and is indefensible, but he had a problem with excluding the similarly disadvantaged groups in the society represented by the SC, ST, SEBC and OBCs, and averred that it amounts to a constitutionally banned form of discrimination. It is discriminatory to help the poorest regardless of the caste of class. Both Chief Justice U.U. Lalit, that is retired now, and Justice Ravindra Bhatt said that the 103rd Constitutional Amendment Act 2019 attacked the foundation principles of the non-discriminatory norm. But the majority opinion of the Supreme Court held that the EWS quota is not discriminatory and does not change the fundamental framework of the Constitution. The Government of India insisted that the 10% quota did not increase the 50% cap on reservations. The EWS quota was described as a separate compartment. The government was questioned by the court several times during the hearing if the EWS quota was to take away any of the 50% from the non-reserved or open positions that are up for grabs and are selected solely based on merit. To fulfill the EWS quota, the government has stated that it will increase the seats in educational institutions by 25%. The centre claimed that it had approved the establishment of more than 2.14 lakh seats in central government educational institutions to guarantee that the EWS quota did not harm the SCs, STs and OBCs arguing that the 10% quota that is allocated for the EWS for the poor would not have an impact on these categories. The government's reason for excluding SC, STs and OBCs was because they had already benefited from the 50% quota available to them. Political reactions have been coming in thick and fast. For its part, the Congress General Secretary Jairam Ramesh has welcomed the judgment on behalf of the party, while the party leaders in Tamil Nadu had tweeted against the judgment and called it regressive. Tamil Nadu CM Stalin had called the judgment regressive and said that the DMK would study the order and then take a call on what to do next. BJP leaders predictably have welcomed the judgment. While in Kerala, the Nair Service Society and the Syro Malabar Church and the Kerala Brahmana Sabha, all under the forward caste in Kerala, have welcomed the Supreme Court order. It now remains to be seen if any review petitions will be filed against the judgment. But as has been seen in the past, review petitions rarely succeed in overturning the original judgment in the Supreme Court. That way, the reservation for the economically weaker sections will stay and give BJP a leg up in the 2024 Lok Sabha elections. Thank you for watching. Jai Hind.
Please subscribe to Nationalist Hub English channel for more interesting videos, and don't forget to like and share this video. Nationalist Hub, it's a news revolution.